Objection. Honourable members, that brings to a close questions for oral answer. I have received a letter from the Honourable Clayton Cosgrove seeking to debate under Standing Order 386 the Waitangi Tribunal's recommendation that the Crown ought not to commence the sale of shares in any of the mixed ownership model companies until the Waitangi Tribunal has had the opportunity to complete its report for the first stage of its inquiry, and the Crown has had its opportunity to give this report and any recommendations it contains in-depth and considered examination. The Waitangi Tribunal has issued an interim report recommending that the sale of shares ought not to commence until it has had the opportunity to complete its report on stage 1 of its inquiry. The government has taken no action. The absence of action on the part of the government is not a particular case of recent occurrence. The time for such a debate is when the government has examined the tribunal's recommendations and announced its response. The application is therefore declined. Point of order, the Honourable Trevor Mallard.
Mr Speaker, I'd like to invite you to look carefully at the application and in particular the case that was drawn to your attention as part of that, and that is volume 638, page 8541, urgent debate into the Commission of Inquiry into Police Conduct. Mr Speaker, that particular case was one which is absolutely parallel to this. It was the receipt of a report to the government from a commission, and of course the Waitangi Tribunal has the same status for these purposes as a commission. It was something which required a response but had not yet had a response from the government, and the Speaker on that occasion, and in fact on a number of occasions in the past, speakers have allowed urgent debates in those circumstances. Mr Speaker, I don't want to push it really hard now, but I would like to invite you to review not your precedents, but previous precedents in this area as to whether or not a matter which has occurred outside, either in a court or in a commission of inquiry or in a tribunal, which requires the government attention, has to have a government decision before we have an urgent debate here. Because in the past, it's been my understanding that having the House express its views before the government made a decision on an urgent and important matter was seen to be valuable.
I accept the points the member has made, that his point of order is well considered. And I've in fact, because of the particular nature of the letter submitted to me that raised this issue, actually already had a look at the matters that the member has just raised. And I think the crux of it boils down to the fact that the Waitangi Tribunal is an independent statutory body. It may have the powers of a commission of inquiry, but it is not a commission of inquiry of the type to which the member referred in his application, a commission set up by ministers to examine matters of government administration. In this particular case, the member referred to police conduct. Clearly, the government is answerable for the findings of such commissions that have been set up by the government, such commissions of inquiry. But with regard to the tribunal, the government is responsible only for its own response to the tribunal's recommendations. There is a statutory difference between a commission of inquiry set up by the government and the Waitangi Tribunal. But in ruling that way, I'm not belittling the very reasonable point the member raised, because it was a point certainly worth examining, and I can assure the member that I had a good look at that because of that very issue. Point of order, the Honourable David Parker.
Would that mean, Mr Speaker, then, that when the government takes a decision as to how it responds to the Waitangi Tribunal's decision, we could make an application which you would then determine on its merits as to whether that decision in response to the Waitangi Tribunal deserved the urgent consideration of the House?
Obviously, when the government makes such a decision, that is a decision of the government, and if an application were to be made, I'd have to consider it on its merits in terms of what was announced and the urgency of the matter and all that kind of thing. But I think the member again raises a perfectly fair point, that because that would be an action of the government. So that is the Honourable Trevor Mallard.
Mr. Speaker, again, we're not relitigating with the hope of getting it, but relitigating or trying to make points for the future. Standing orders doesn't say that these debates result from decisions of the government. And I think that's something which is that the urgent matter does not have to be a decision of the government. And I think sometimes, sir, you have been coming back to that in your rulings when that is not a requirement. And as the point that I made earlier, some of us hope that Parliament might be able to, in the future, influence decisions of the government which are required to be made.
I hear the member, and the member is quite right again, that they're matters that involve the administrative responsibility of the government. I accept that point. It is well made. However, with this particular issue, the Waitangi Tribunal, the points I've covered remain that it is rather different from statutorily different from a commission of inquiry set up by the government. The Waitangi Tribunal is an independent body, and that's what makes it rather different. However, I'm aware of what the member is pointing out, that often the benefit of a debate in the House would be rather greater on some occasions prior to a response occurring. I can hear where the member's going to, and that's why I don't want to preempt any possibilities, because any application must be considered on its own merits, and I don't want to preempt any possibilities. But I've noted the point the member made, and I can understand why it is made. I now call on Government Orders of the Day numbers 1 to 3.
Biosecurity law